guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. I am back and I have the 52-page closing argument from the defense, or as I like to call them, Team Zeigler. So we're going to jump right in because, like I said, it's 52 pages long and it's going to take some time to read and get through. But I haven't read it yet, so we're going to kind of read it together. That way you're kind of getting the first impressions the same time as I am. So here is the closing argument that I was able to get a hold of thanks to Lynn. And I'm looking forward to going through it with you guys. Real quick before I dive in, I am like 3 subscribers away from a major milestone here on the channel of 10,000 subscribers. So if you are listening and you haven't subscribed yet, I would really appreciate that. So if you could hit that subscribe button, I would be greatly appreciated. And also, if you like the content, it's always helpful to hit the thumbs up, the like button, because it helps the algorithm and all that fun stuff here on the YouTube streets. So this is obviously the closing argument, defendant's written closing argument, and it has table of contents because it's very long. Well, the state's was 61 pages, 62 or 3. Anyway, it was a little bit longer than this, so honestly, I'm not surprised. And they have it organized really well, obviously, because there's a table of contents. And I'm not going to read this, so if you want to freeze it and read it, but we're just going to go through it. So I'm just going to get past the table of contents and get right into the meat of the closing here. And then there's table of authorities. See, let's see. And that's all the cases it looks like here as well. Let's see. All right. So here we go. So the good news is we're on page 5, so that helped a little bit. Defendant William Thomas Zeigler Jr., through his undersigned counsel, files and serves his written closing argument pursuant to Florida Rule of Criminal Procedure, Rule 3.851 F5E, following the evidentiary hearing held from December 1st, 2025 through December 5th, 2025 on Mr. Zeigler's motion to set aside convictions based on newly discovered evidence. Introduction. 50 years ago, a jury convicted Mr. Zeigler of 4 murders after a trial riddled with flaws. That same jury rejected the death penalty after mere minutes of deliberation, with one juror stating in open court that she believed Mr. Zeigler was innocent. Mr. Zeigler has been fighting to prove his innocence ever since. Finally armed with the results of comprehensive DNA testing, he moved this court for an order vacating his convictions because the newly discovered evidence dramatically undermines the basis for his convictions and establishes reasonable doubt as to his guilt. The court heard evidence over a week-long evidentiary hearing. A review of the evidence shows that Mr. Zeigler met his burden and is entitled to relief. It is now undisputed that key aspects of what the state told the jury were not true. That alone requires vacatur of Mr. Zeigler's convictions. Furthermore, the undisputed evidence, pursuant to Rule 3.851 F5E, defendants' proposed findings of fact and conclusions of law are appended as Exhibit A, including Exhibit A. Defendant's written closing argument does not exceed 60 pages. And conclusions presented by Mr. Zeigler's experts demonstrate that Mr. Zeigler is innocent, far surpassing the requirement that Mr. Zeigler demonstrate reasonable doubt of guilt. Based on that, Mr. Zeigler's convictions must be set aside. The standard for vacating a conviction based on newly discovered evidence is well settled. The convictions must be set aside if the new evidence weakens the case against the defendant so as to give rise to a reasonable doubt as to his culpability. Swofford v. State, Florida 2013. emphasis added. In conducting its analysis, the court conducts a cumulative analysis of the evidence, including all evidence discovered since Mr. Zeigler's 1976 trial, and considers the newly discovered evidence as against the evidence which was introduced at the trial. ID at 767, internal quotations and citations omitted. Mr. Zeigler has satisfied this standard in two separate ways. First, he demonstrated, and indeed the state concedes, that the DNA test results disprove key aspects of what the state told Mr. Zeigler's jury. Vitor is required on this basis alone. At trial, the state emphasized to the jury what it claimed was proof that Mr. Zeigler savagely and severely beat his father-in-law, Perry Edwards. The state now concedes that the evidence probably doesn't bear that out. Exhibit B. Based on the DNA results, the state admits there is no physical evidence indicating Mr. Zeigler's struggle with Perry at all. That is enormously significant, not least because the evidence shows that someone did beat Perry severely before firing the final gunshots that killed him. If Mr. Zeigler was not that person, then someone else, not Mr. Zeigler, beat Perry. The state also told the jury, including through expert testimony, that the physical evidence demonstrated the sequence of the murders. This was key because the state contended that Mr. Zeigler committed 4 murders by himself in the same location on the same evening. To prove guilt beyond a reasonable doubt, the state had to explain to the jury what each victim was doing while Mr. Zeigler was supposedly busy attacking or shooting the others. The state's expert now concedes that there is no basis to determine the sequence in which the victims were killed. That is especially damaging to the state's case, since the state also concedes that the physical evidence and DNA results show that Perry was moving all over the furniture store where the murders occurred after being shot and bleeding freely from his wounds. According to the state's current expert, Perry was roaming the furniture store bleeding without struggling with anyone. To maintain Mr. Zeigler's conviction, the state would need to be able to point to evidence showing beyond a reasonable doubt what Perry and the other victims were doing while the crimes were being committed, and how Mr. Zeigler could have controlled so many victims by himself without fighting with any of his relatives. No such evidence exists. The state also presented evidence to the jury that Mr. Zeigler repossessed his wife's clothing after her death, confronted with DNA results indicating that Charles Mays and Mr. Zeigler may have left DNA on Eunice's clothing. The state now argues that, contrary to what the state told the jury at trial, Eunice's clothing was not staged. However, the state is not permitted to defend a conviction based on new theories and expert opinions that were never presented to a jury, particularly where the state's new evidence contradicts what the state told the jury at trial. If the state convicts a defendant based on evidence that turns out to be bad, the conviction cannot stand. If the state wants to change its story as a material aspect of its case, it must present its new evidence to a new jury. Second, in addition to showing that Mr. Zeigler was convicted based on faulty evidence, Mr. Zeigler has presented newly discovered evidence that raises reasonable doubts about his guilt. The newly discovered evidence that Mr. Zeigler did not struggle with Perry proves both what the state told the jury was false and that Mr. Zeigler did not beat or murder Perry. The medical examiner's report showed that someone inflicted no fewer than 11 separate lacerations to Perry's head, a region known to bleed heavily, in addition to 4 gunshot wounds, including 2 in the right temple at very close range. Whoever caused all of these injuries to Perry would surely have been covered in a very significant amount of Perry's blood. As the state's own experts, David Barr, testified previously, there would have been quite a bit of transferred blood that would not have been hard to find through DNA testing. Exhibit C, Barr testimony. Now, the state concedes that the evidence established an expectation of backspatter when Perry was on the ground and there was a coconal shape of spatter produced, Exhibit B, but DNA testing did not find any such blood on Mr. Zeigler. Mr. Zeigler's clothing was tested extensively for DNA. Perry's blood wasn't there. And the state's expert testified after reviewing DNA evidence that there is no physical evidence that Mr. Zeigler beat or even struggled with Perry at all. It's hard to imagine new evidence that could more severely undermine the state's case. DNA testing also confirmed that Mr. Zeigler had no blood from Virginia Edwards, Virginia, or Eunice on his clothing either, despite exhaustive testing. That is significant because it is undisputed that their murders also likely produced backspatter. Virginia was shot at close range with large caliber bullets that did not exit. As the state conceded at the hearing, there was probably backspatter produced. Experts for both the state and the defense testified that Eunice's shooting also likely produced backspatter. None was found on Mr. Zeigler. These findings are all the more significant because the DNA results show that Perry shed his blood all over the crime scene, from that far northeast corner, which is nearly opposite to where he was found, to the kitchen where Eunice was found, to Mays's pants, to the west wall of the furniture store. According to the state's expert, Miss Anna Cox, Perry suffered what she described as a bleeding injury that was uninhibited from bleeding freely and uninterrupted. And that was before Perry suffered the blows and close-range gunshots to the head that ultimately led to his death. None of that was found on Mr. Zeigler. The DNA results also add to the already substantial evidence that Mays was a perpetrator, not a victim. The jury knew that Mays had parked his van in a very suspect location. He was supposedly at the furniture store to pick up a television, which in 1975 would have been both bulky and heavy. But Mays didn't park by the front door of the furniture store or even by the back door. Instead, he chose to park in the parking lot of a nearby hotel, separated from the furniture store by a 6-foot-tall fence with no gate. None of that makes any sense. A jury considering that evidence would now have additional powerful new evidence. A jury would hear that Mays had Perry's blood soaked onto both legs of his pants. A jury would also hear that even the state concedes that Mays' bloodstains are consistent with him kneeling in a pool of Perry's wet blood. Perry's blood is all over Mays, not Mr. Zeigler. The state has no way to explain how Mays could have innocently knelt in Perry's blood for long enough to saturate both legs of his pants, while Mr. Zeigler, the man who supposedly murdered both Perry and Mays, has none of Perry's blood on his clothes. The jury that convicted Mr. Zeigler was also told at trial that someone had repositioned Eunice's clothing after she had been killed. The locations a person manipulating her clothing would have touched were all tested for DNA. The profiles that came back were all consistent with Mays, not Mr. Zeigler. And each profile had a different combination of alleles, making it more likely that Mays was the one to adjust Eunice's clothing after she had been killed. Now remember, just to deviate for 1 second, remember, she had her hand in her pocket. That is the most bizarre thing I've seen. I don't think I've ever seen someone with a hand in their pocket. Of course, I'm sure it's out there somewhere. Finally, the DNA results also undermine another key pillar of the state's case, their assertion that Mr. Zeigler shot himself. The undisputed DNA evidence shows that 1. Mr. Zeigler has his own blood spattered on multiple locations on his pants, and 2. That spatter was produced by someone hitting Mr. Zeigler in the areas he was bleeding from, his gunshot wounds, after he was shot. It would make no sense for Mr. Zeigler to beat himself in his own gunshot wounds. Yeah, that's awkward, isn't it? The test results demonstrate that Mr. Zeigler was engaged in a violent struggle with someone else at the time he was shot. Strong evidence that he was shot by someone else and that his gunshot wound was not self-inflicted. The state did not contest any of this at the evidentiary hearing. Taken cumulatively together with all the other evidence, as they must be, these findings establish reasonable doubt. Mr. Zeigler also presented other evidence at the hearing. He presented the testimony of a veteran law enforcement officer on the flawed and unreliable manner in which the original police investigation was conducted and the other evidence that makes it highly unlikely that Mr. Zeigler shot himself. Mr. Zeigler also presented an eyewitness whose account is inconsistent with the state's chronology as well as recorded proof of the state's efforts to pressure and coach witnesses. Evidence of such witness coaching would be highly likely to undermine the prosecution's credibility, further establishing reasonable doubt in a jury's mind. Mr. Zeigler also presented testimony from one of the state's star witnesses, Felton Thomas, who stated that key aspects of his trial testimony were false. In light of all this evidence, the court should do the just and fair thing, grant Mr. Zeigler's motion, and vacate his convictions. So that is the main, obviously, opening here. Then we're going to jump to the second part. Now, undermined trial evidence cannot sustain Mr. Zeigler's conviction in light of the newly discovered evidence. A. The newly discovered evidence must be compared to the evidence and arguments at trial. To succeed on a motion to set aside convictions based on a newly discovered evidence, a defendant must meet two requirements. First, the evidence must not have been known by the trial court, the party, or counsel at the time of trial, and it must appear that the defendant or defense counsel could not have known of it by the use of diligence. Johnson v. State, Florida 2010. Second, the newly discovered evidence must be of such nature that it would probably produce an acquittal on retrial. And that is also quoting Jones v. State, and that's 1998. Actually, that's quoting Jones v. State. Sorry, different case. Mr. Zeigler amply satisfied both requirements. His motion should be granted. Newly discovered evidence satisfies the second prong if it weakens the case against the defendant so as to give rise to a reasonable doubt as to his culpability. Johnson, and they're quoting 27 Southern 3D at 18, quoting Jones 2, 709 Southern 3D at 526, the court must conduct a cumulative analysis of all the evidence so there is a total picture of the case and all of the circumstances of the case. And that is quoting Swafford, quoting Lightburn versus State, 742 Southern 3D, that's Florida, 1999. Under this cumulative analysis, the court must evaluate all the admissible newly discovered evidence at this hearing in conjunction with newly discovered evidence at the prior evidentiary hearings, and then compare it with the evidence that was introduced at trial. Jones 2, emphasis added. For example, in Hildwin v. State, the Florida Supreme Court vacated defendant's death sentence and remanded for new trial after DNA testing completely changed the nature of the evidence relied upon by the state at trial. Florida 2014. The court particularly noted that at trial, the state prosecuted the case based on a false theory of scientific evidence that was woven through a presentation of evidence and argument, scientific evidence that was totally discredited. The Florida Supreme Court reasoned that the state could not later distance itself from the evidence and theory it relied upon at trial by arguing that it could have still convicted the defendant without any of the now discredited scientific evidence. The court could not turn a blind eye to the fact that a significant pillar of the state's case, as presented, the court could not turn a blind eye to the fact that a significant pillar of the state's case, as presented to the jury, had collapsed, and that at the same time actually supported the defense theory presented at trial. Similarly, in Swofford v. State, Florida 2013, the Florida Supreme Court vacated defendant's sexual battery and first-degree murder conviction where the newly discovered forensic evidence changes the entire character of the case and affects the admissibility of evidence that was originally presented to the jury. And in Aguilar-Jarquin v. State, Florida 2016, the Florida Supreme Court vacated the defendant's conviction where the importance of the newly discovered evidence is plain when compared with the evidence that the state used to convict the defendant. When a cumulative analysis of the admissible evidence weakens the case against the defendant so as to give rise to a reasonable doubt as to his culpability, Jones 709 Southern 3D at 256, the court must grant the requested relief. See Aguilar-Jarquin 202 Southern 2D at 795, Hildwin 141 Southern 3D at 1180, Swofford 125 Southern 3D at 778, Johnson v. State 44 Southern 3D 51, Florida 2010, as revised on denial of writ September 2nd, 2010. Vacating death sentence and remanding for a new sentencing where newly discovered evidence showed defendants' incriminating statements were obtained in violation of the Sixth Amendment. State v. Mills, Florida 2001, granting new sentencing hearing where the newly discovered evidence, when considered in conjunction with the evidence at Mills's trial and 3.850 proceedings, would have probably produced a different result at sentencing. And there are some footnotes here in case you guys are interested. I'm not reading those, just so you know. Neely v. State, 565, Southern 3D, 337, 345, Florida 4th DCA 1990, vacating conviction and remanding for new trial where newly discovered evidence would have prevented guilty verdict. Clugson v. State, Florida 4th DCA 2000, remanding for a new trial because no physical evidence connected appellate with the crime, and given the weakness of the state's case, we believe the newly discovered evidence would probably result in an acquittal on retrial. Mr. Zeigler amply satisfied these standards with the evidence he presented during the evidentiary hearing for two separate reasons. First, as the state and its expert conceded at the evidentiary hearing, key aspects of what the state told the jury at trial are not true or not supported by the evidence in light of the DNA test results. These concessions alone require that Mr. Zeigler's conviction be vacated. The state cannot maintain a criminal conviction in a murder case when it has admitted that it obtained that conviction by presenting evidence and argument on material topics that are now known to be false. If what the jury based its conviction on was not true, the conviction cannot stand. Second, in addition to refuting key testimony from the trial, the newly discovered evidence amply establishes reasonable doubt as to Mr. Zeigler's guilt. The evidence adduced at the evidentiary hearing shows that in part Mr. Zeigler lacked blood from any member of his family anywhere on his clothing. It is inconceivable that Mr. Zeigler could have murdered all three of Perry, Virginia, and Eunice without managing to get a drop of their blood on his clothing, and this fact, at the very least, creates reasonable doubt of his guilt. See, I feel like that particular portion just should be like mic drop, but yeah. By contrast, Mays, whom the state conceded at trial was an innocent victim, had large quantities of Perry's blood soaked into both legs of his pants, bloodstains that even the state's expert conceded were consistent with Mays kneeling in a pool of Perry's liquid blood. DNA consistent with Mays was also found on multiple locations of Eunice's coat, and not just any locations, but the very locations a person would have needed to touch to reposition Eunice's clothing after she had been killed. The evidence also demonstrates that someone was beating Mr. Zeigler after he was shot. Powerful evidence that Mr. Zeigler's gunshot was not self-inflicted, but rather inflicted by the person or persons who were still beating Mr. Zeigler even after they had shot him. These physical findings, among others, undermine the heart of the state's case against Mr. Zeigler, amply establish reasonable doubt as to guilt, and accordingly require a vacatur of Mr. Zeigler's convictions. B. The state's now undermined evidence and arguments at trial. In Mr. Zeigler's trial, the state presented extensive witness testimony and argument as to key facts that have now been undermined or proved to be false by the newly discovered evidence Mr. Zeigler adduced at the evidentiary hearing. Mr. Zeigler beat Perry. The state now concedes that, contrary to what the state told the jury, there is no physical evidence that Mr. Zeigler beat or shot Perry. At trial, the state repeatedly emphasized to the jury that Mr. Zeigler fought with Perry in a life-or-death struggle, and that during that struggle, Mr. Zeigler beat Perry extensively before ultimately shooting him twice in the temple at close range. In its opening statement, the state argued to the jury that Perry put up a fight and was beaten severely about the head, and then he was shot twice at very close range in the side of the head. The state then called Professor Herbert McDonald, who Anna Cox called the father and pioneer of bloodstain analysis, to testify about how the bloodstain evidence at the crime scene proved that Mr. Zeigler savagely beat and then murdered Perry. Professor McDonald was a star witness. His testimony spans 128 pages of the trial transcript, demonstrating his importance to the state's case. This is Exhibit D. He testified in detail how Perry was beaten and then killed, and why the physical evidence inculpated Mr. Zeigler. McDonald told the jury that Perry was beaten both on and near the location where he was found. Blood spatters emanating from the area of Perry's head were consistent with his head being on the floor at the time that the beating was administered. And there were also blood patterns of a more elliptical nature, which came from some distance higher, probably 2 or 3 feet high, not directly on the floor, all which allegedly evidenced the violent nature of Perry's murder and Mr. Zeigler's culpability. Dr. G.V. Ruiz, the medical examiner, testified that Perry sustained 14 separate traumatic areas. During Mr. Zeigler's cross-examination, the state asked Mr. Zeigler, "You can't tell me how you held Perry around the neck and clubbed him with your right hand as you held him with your left?" During the state's closing argument, the state again emphasized to the jury that they should examine Mr. Zeigler's clothing, and will see a big blood stain right in the area where Edward Williams said he saw a dark stain. That could have gotten there only by his having someone in his arm who was type A blood. Who was bleeding type A blood? And later, during the state's closing argument, the state argued that Perry Edwards fought for his life, while he had bullet holes through his shoulders and through his ear, and that he was clubbed in the head with a metal crank and then executed with 2 bullets from close range squarely into his skull. That Perry was engaged in a prolonged struggle before his death was a key part of the state's theory, both at trial and on direct appeal. Indeed, the Florida Supreme Court found, in affirming Mr. Zeigler's conviction, that the evidence presented to the jury demonstrated that Perry probably surprised defendant with his strength and stamina as they struggled for some time. After defendant subdued Perry and rendered him harmless, defendant shot him. Zeigler versus State, Florida, 1981. Emphasis added. Perry struggled with a defendant. Defendant subdued Perry, rendered him harmless, and shot him once while he lay on the floor. Emphasis added. There can be no meaningful dispute as to the materiality of the state's concession, given that Mr. Zeigler was convicted of murdering Perry, and that Perry's autopsy reports show that someone, and if not Mr. Zeigler, then someone else, did beat and shoot Perry. The state now concedes that there is no physical evidence that Mr. Zeigler struggled with Perry at all. The evidence revealed the order of murders, Another key aspect of the state's case at trial was the sequence in which the murders occurred. This was critical because the state was arguing that Mr. Zeigler single-handedly committed all of the murders. For that to be plausible, the state needed to be able to explain to the jury the order in which the murders occurred and what the other victims were doing while Mr. Zeigler was allegedly occupied murdering or attacking other victims. The state relied on physical evidence to construct a sequence for the murders and to support their theory that one man was able to murder 4 people in one evening in one location. The state argued that Mr. Zeigler first killed Eunice, taking her completely unaware. Next, he beat Perry severely before killing him, and then he killed Virginia. See Zeigler recounting that Mr. Zeigler first killed Eunice quickly and for her unexpectedly, then struggled with and killed Perry, then went in search of Virginia and shot her in the head. The state further claimed that after killing his family, Mr. Zeigler left the furniture store, went to the Orange Grove with Mays and Felton Thomas, drove back to the furniture store, drove back home, drove to the furniture store again, and then entered the furniture store with Mays, who he then killed. This is referencing Exhibit D. Under the state's order of events, Mays did not arrive at the furniture store until significantly after Mr. Zeigler murdered his family. When reviewing the state's trial exhibit 43, a photo of Mays's body, Professor McDonald testified that there must have been at least 15 to 30 minutes between the time the large areas were put down or smeared and the other blood came to rest upon them. The state's expert now concedes that that is not possible based on the evidence to assign a sequence to the murders. Exhibit B. Eunice's coat was repositioned. Professor McDonald also testified that Eunice's coat had been repositioned after the blood had dripped onto her. Professor McDonald said Eunice's coat would have had to have been opened rather than closed, as it was when she was found, or that someone with blood on their hand left those spots from the fingertips. Exhibit D. The state now maintains that this too was incorrect. Mr. Zeigler shot himself. Finally, the state also argued that Mr. Zeigler shot himself in the abdomen. This was a critical part of the state's case because if Mr. Zeigler did not shoot himself, then someone else shot him, which is exactly what Mr. Zeigler testified occurred. But the state argued in both its opening and closing that Mr. Zeigler's gunshot wound was self-inflicted. During its opening, the state said, in desperation, he shot himself to try to cover the murders up. And during its closing, the state reiterated multiple times he was shot by himself through his own desperation. It was plain old .38 ammunition. That's the one he couldn't wipe because that's the one he used to shoot himself. And he did shoot himself before he made the phone call or after. This theory has now been thoroughly undermined by the newly discovered evidence. C. The state concedes at the evidentiary hearing that the newly discovered evidence contradicts key evidence in arguments at trial. The state now concedes that based on the newly discovered evidence, key aspects of the evidence and argument the state presented to the jury to secure Mr. Zeigler's conviction were in fact not true. Mr. Zeigler did not beat Perry. When asked by the court whether the state was arguing that the new evidence is entirely consistent with what was argued at trial, the state responded, I am conceding, Your Honor, that Mr. Egan did make some statements. They were general statements, so I'm not sure exactly what Mr. Egan was referring to. He did say multiple times, Perry fought for his life. Fought for his life does imply a struggle. And I see why the Florida Supreme Court wrote their opinion the way they did, given the way Mr. Egan characterized the evidence. Exhibit B. And when asked, are you conceding that he also implied and asking Mr. Zeigler as if it were a fact that Mr. Zeigler held Mr. Perry under his left arm and beat him, are you conceding that that happened? The state again responded in cross-examination, yes, Your Honor, and I'm also conceding that the evidence probably doesn't bear that out. The evidence does not reveal sequence. In addition, the state's expert, Ms. Cox, admits that the evidence does not show the sequence of the murders. Question, were you able to form an opinion as to whether Virginia Edwards and Eunice were all were the first to die, so to speak, or to be injured in this, followed by Perry Edwards and then Charlie Mays. Answer: I can't assign a sequence. In 1976, the state told the jury that the evidence proved when each person was killed. Armed with DNA and test results, which were not available at the time of trial, the state now concedes that the evidence does not reveal a sequence. It never did. The testimony and argument that the state presented to the jury about sequencing was false and not supported by the evidence. The state's current expert also rejects as incorrect the evidence the state presented at trial about Eunice's body and clothing being moved after her death, other than stating that Eunice's head was turned when the police checked her neck for a pulse. Question: and other than her head being moved, and this is states A21 and A22 on the screen, other than her head being moved, did you see any post-incident alterations? Answer: no. D. The state cannot change its theory. The state argues that the question is not, did the state present a theory at trial that was different? But these two questions are inextricably linked, as the Florida Supreme Court acknowledged in Hildwin. In Hildwin, as here, the state had presented scientific evidence that the defendant had murdered the victim, including laboratory analysis, concluding that semen on the victim's underwear and saliva on a rag found at the scene of the crime were consistent with the defendant. In post-conviction proceedings, DNA testing showed that the semen and saliva were not that of the defendant. The Florida Supreme Court reversed the post-conviction court's denial of a new trial because the scientific evidence presented at trial was shown to be incorrect. The Supreme Court relied heavily on the fact that at the original trial, the state had emphasized the importance of the physical evidence that the jury likely relied on to convict the defendant, because a significant pillar of the state's case, as presented to the jury, has collapsed, and that the same evidence actually supports the defense theory that Hildren presented at trial. The same is true here. The state has conceded that several pillars of the state's case have collapsed, leading to the same conclusion reached in Hildwin, that a new trial is required based on new and inconsistent scientific evidence. 3. The newly discovered evidence creates reasonable doubt. A. The newly discovered evidence is comprehensive. Over the course of more than a year, Forensic Analytical Crime Lab, FACL, senior analyst Kristen Hardy-Connell conducted a forensic examination of 43 items of evidence, conducting 232 samples for testing. Exhibit B. Those 232 samples often included multiple stains gathered into single sample for testing purposes, making the number of blood spots tested substantially higher. Exhibit P. Recommendations about what items of evidence to test were based on Ms. Hardy-Connell's expertise in consultation with both the defense and the state in weekly and biweekly calls, as well as email communications. Exhibit B. FACL Senior Analyst Kenton Wong, a highly experienced bloodstain expert, also assisted in examining the evidence and recommending areas for testing to the state and the defense. Ms. Hardy-Connell has a Bachelor of Science degree in chemistry with a focus in forensics and a minor in biology, and a Master of Science degree in forensic science. After completing her graduate degree, she spent 5 years working as a forensic scientist for the Montana Department of Justice and then the Washington State Patrol before joining FACL in 2022. Exhibit B. Mr. Wong has a Bachelor of Science degree in environmental toxicology with a minor in biological sciences and a Master of Science degree in biological sciences. Exhibit B. Mr. Wong worked as a criminologist with the San Mateo County Sheriff's Crime Lab for approximately 17 years before joining FACL in 2006. Exhibit B. At no point during the more than year-long testing process did Ms. Hardy-Connell ever suggest an item for testing that the defense declined to test. Where samples were limited, DNA would be fully consumed by Ms. Hardy-Connell's testing. The state instructed Ms. Hardy-Connell not to proceed with testing those samples to preserve the future option to send them to another laboratory. The state was also free to request testing of additional items, and it did so. The state requested that FACL test a pair of eyeglasses for DNA. Not only did the defense not object, it paid for the testing. FACL conducted comprehensive testing on Mr. Zeigler's clothing. Ms. Hardy Connell took 19 samples from Mr. Zeigler's shirt, 15 samples from Mr. Zeigler's pants, 8 samples from Mr. Zeigler's shoes, and 5 samples from Mr. Zeigler's socks, for a total of 47 samples from Mr. Zeigler's clothing. B. Mr. Zeigler's clothes had no blood from any member of his family. Mr. Zeigler was convicted of murdering 4 people with gunshots to the head, 2 of which were also beaten. The blood from these killings must have spattered on their assailant. Yet Mr. Zeigler had no blood spatter from his family members. He cannot be their killer. The only blood found on Mr. Zeigler was either his own or from Mays, a man with whom Mr. Zeigler has always maintained he fought with and tried to shoot in self-defense the night of the murders. None of Mr. Zeigler's clothing had Eunice's blood on it. None of Mr. Zeigler's clothing had Virginia's blood on it. Mr. Zeigler's shirt, pants, and socks did not have Perry's blood on it. Zeigler's shoes had 2 samples where Mays was identified as the major DNA contributor and Perry was identified as a minor DNA contributor, in one case contributing less than 1% of the DNA found in the sample. When a DNA sample has blood in it, the major contributor of DNA is the source of the blood, meaning these samples contained Mays's blood. It is not possible to tell what biological source the minor DNA contributor came from. It could be skin cells, small amounts of saliva, or small amounts of blood. It is also not possible to sequence the deposition of DNA in a mixed sample, so there is no way to determine whether the spot itself was mixed or whether Perry's DNA was on Mr. Zeigler's shoes, perhaps by the virtue of Perry staying at the Zeigler's residence prior to the night of the murders. Perry was the 21% contributor to one sample and a less than 1% contributor to the other. This directly refutes a key piece of the state's evidence at trial. Despite Mr. Egan's statements to the jury, the newly discovered evidence proves that Mr. Zeigler did not hold Perry around the neck and club him with your right hand as you held him with your left. Exhibit D. The only blood found on Mr. Zeigler's clothes was either from himself or from Mays. This is consistent with Mr. Zeigler's trial testimony and entirely inconsistent with the state's theory. The state's position at the close of the evidentiary hearing was that Mr. Zeigler had Mays' blood on his clothing because Mr. Zeigler beat and killed Mays. Exhibit B. The state's arguments at trial would be severely undermined by the evidence that Perry's blood is not to Mr. Zeigler's clothing. The state argued that Mr. Zeigler beat and killed Perry. Perry's blood was found dripped and spattered all over Eunice's clothing and in numerous locations throughout the furniture store. And the undisputed evidence is that Perry's murder resulted in a large volume of backspatter blood toward his perpetrator. It is inconceivable that Mr. Zeigler could be that perpetrator and not get Perry's blood on his clothing. That finding alone establishes reasonable doubt as to Mr. Zeigler's guilt, particularly because Mr. Zeigler also had none of Virginia's or Eunice's blood on him either. Richard Eichenblum is a forensic scientist with his own company, Independent Forensic Services. He has a degree in analytical chemistry from the Technical School for Laboratory Education, a biochemistry degree from the University of Rotterdam, and completed an understudy program in bloodstain pattern analysis by the Ontario Provincial Police in Canada. He has worked in the field of forensic science for over 30 years. Exhibit B. Mr. Eichenblum conducted a review of the DNA reports generated by FACL in combination with a bloodstain pattern analysis on the stains. He reviewed very detailed and very high-quality photographs that FACL took of the stains on the items that they tested. He reviewed hundreds of photographs. Mr. Eichenblum also reviewed the medical examiner reports of the victims. Mr. Eichenblum testified that Perry's injuries produced blood spatter, and one could expect to see back spatter on the clothing of the perpetrator. Perry also either dripped or spattered blood in multiple locations throughout the furniture store, meaning he moved around after suffering injuries. Mr. Eichenblum also testified that Virginia's murder, specifically the gunshot to her head, would have produced backspatter, which may have gotten on the clothing of the perpetrator. The state's expert, Anna Cox, likewise identified that Perry's blood was shed throughout the furniture store and that he produced blood spatter. Ms. Cox testified that Perry, before he was laying on the floor, had a bleeding injury that was bleeding downward and bleeding freely, which supports the identification of his blood on the green pillow from the couch in the northwest corner. She went on to say that she can't exclude him as depositing some of the other drip stains and patterns within the store as well, and that it was undocumented in the scene that Perry could have been moving around the scene as he was dripping blood. Ms. Cox also identified spatter from Perry at the scene. She identified a conical spatter pattern that radiates outward from Perry Edwards' head, and that on the floor above his head, on the east side above Perry's head, there's spatter there. That can't be excluded. It's from the beating. Ms. Cox also identified spatter around Eunice. In reviewing photographs of the furniture store, Ms. Cox identified spatter on the door frame that leads from the showroom to the break room where Eunice was found. This is consistent with the theory that whoever killed Eunice would have gotten back spatter on them. She was shot in the head by an RG revolver. Eunice was shot completely unaware that one of those RG-38 shot her in the head, and I would suspect she dies almost instantly. Eunice's killer would have had to have been near her in order to shoot her in the head with a pistol in a small room. The state conceded that there was probably backspatter produced when Virginia was killed. Exhibit B. The state concedes that there was probably backspatter produced when Virginia was killed. The state's expert initially sought to call this into question by referring to a photograph, State Hearing Exhibit 5 at photograph 10, which shows Virginia on a dark brown shag carpet. Ms. Cox testified that there is no spatter on her head on the items around her head. On cross-examination, however, she conceded that backspatter would have gone towards the shooter and thus would have not have been deposited on the furniture depicted in the photograph, which was behind Virginia's body. Further, it would be nearly impossible to identify spatter stains on the dark shag carpet in the grainy 1975 photograph, which Ms. Cox described as underexposed. The state acknowledged as much during its closing argument, admitting, yeah, sure, maybe there would have been a couple of misting stains you found on the floor. In sum, the evidence in record is that the killing of all three of Mr. Zeigler's family members would likely have produced backspatter, but none of that backspatter landed on Mr. Zeigler, the person convicted of killing them. That fact alone establishes reasonable doubt. C. Mr. Zeigler did not reposition Eunice Zeigler's coat after her death, but Charles Mays may have. At trial, Dr. McDonnell testified that Eunice's coat was repositioned after her death. This assertion continues to be supported by the newly discovered evidence. Mr. Wong, during his examination of Eunice's yellow blouse, identified apparent impact-like spatters of small diameters on the front central regions of the shirt, as well as the end of the left sleeve, as well as areas of saturated blood on the upper right chest area and the end of the left sleeve. But these areas were covered by her coat, which was buttoned when she was found. Mr. Eichenblum testified that the bloodstains on Eunice's shirt were evidence that Eunice was repositioned after her death. When FACL tested for DNA at locations that someone repositioning a coat would likely have touched, only one person known to be in the furniture store that night of the murders, other than Eunice herself, could not be excluded as source of the minor DNA contributors: Mays. FACL determined that Mays was the only known DNA profile that could not be excluded as a DNA contributor to the places the killer likely touched on Eunice's coat. FACL found limited support for the proposition that Mays was a contributor to samples taken from the front of Eunice's left cuff, the back of her left cuff, the front of her left cuff, and her right pocket. All the other known reference individuals, including Mr. Zeigler, were excluded as potential contributors. Further, the DNA matches contained a different set of alleles in each location. This decreases the likelihood that it was DNA from a different person with a few alleles in common with Mays, and increases the likelihood that it was Mays's DNA. Exhibit B. This is because when each sample has a unique set of alleles, each of which match May's, none of which contain identical alleles to one another, the likelihood that May's happens to have each of the various combinations but is not the source of the DNA decreases. There would have been no reason for Mays to come in contact with Eunice's coat unless he was involved in the murders. And critically, the newly discovered evidence proves Mr. Zeigler was not the person who repositioned his wife's coat, further establishing reasonable doubt. D. Perry Edwards' wet blood on Charlie Mays' pants disproves the state's sequence of events. Unlike Mr. Zeigler's clothing, Mays' pants had Perry's blood in multiple locations. FACL took 14 samples from Mays' pants. Perry was the sole or major contributor to 3 of those samples. Perry's blood was found on Mays' left knee, left shin, and right hem. Perry's blood was on both of his legs and at multiple heights. The blood stains these samples were taken from are large, as evidenced by photographs taken at the crime scene. This contradicts the state's theory at trial that Mays did not arrive at the furniture store until substantially after Mays was killed. Mays must have been present while Perry's blood was wet. Both Mr. Eichenblum and Miss Cox agree that the stains on Mays' pants could be consistent with Mays kneeling in a wet pool of Perry's blood. Exhibit B. E. Someone else shot Mr. Zeigler and then beat him. No one disputes that Mr. Zeigler was shot. The state and defense disagree about by whom he was shot. The state's theory is that Mr. Zeigler committed all 4 murders, called Judge Van Deviter's house, and then shot himself, knowing that help was on the way. The newly discovered evidence shows that that is not what happened. Mr. Zeigler's pants had blood spatter on the back of his right knee and the front of the white waistband area that DNA analysis show is Mr. Zeigler's own blood. Exhibit B. Exhibit B at 14, identifying numerous small, approximately 1 to 3 millimeter diameter blood spatters were observed on the back of both right and left legs. Exhibit O at 21, identifying locations of samples 31 through, looks like I1I, right front waistband area, and 31 through 10, right back of the knee, 38, 40, Exhibit P, FACL photographs, and they list obviously that information there. These spatter stains on the front and back of his body could not have come from Mr. Zeigler shooting himself in the abdomen, because in order for the stains on the front of the waistband to be there, Mr. Zeigler's leg would have had to have been in front of his abdomen, while in order for the stains on the back of his leg to be there, his leg would have had to have been behind his abdomen. Exhibit B. These cannot both be true. Instead, these spatter stains were caused by impact to Mr. Zeigler's fluid blood. They are consistent with having been deposited by a beating. The only bleeding wounds Mr. Zeigler had on Christmas Eve 1975 were his gunshot entry and gunshot exit wounds. Exhibit D, testimony of Dr. Albert Gleason that during Dr. Gleason's initial examination, other than the gunshot wound, Mr. Zeigler had a bruise on his right occipitable region, a small abrasion and black and blue area on the front of his leg, a small black and blue area on his left kneecap, and a superficial abrasion on his left cheek, none of which were bleeding. The only way that Mr. Zeigler's own blood could have been deposited on his pants from a beating would be if Mr. Zeigler was beaten after he was shot. But under the state's versions of events, no one else was alive in the furniture store after Mr. Zeigler shot himself. There is no way under the state's versions of events to explain the newly discovered evidence of spatter stains consisting of Mr. Zeigler's own blood on his pants. Perhaps, realizing this, the state chose not to ask Mr. Eichenblum any questions about this conclusion, nor did they ask Miss Cox about it. This evidence directly contradicts a central part of the state's case. F. The newly discovered evidence is consistent with Mr. Zeigler's testimony at trial. While the newly discovered evidence contradicts key parts of the state's trial testimony and arguments, it is consistent with Mr. Zeigler's versions of events of December 24th, 1975. Mr. Zeigler testified that he arrived at the furniture store, attempted to turn on the lights that did not turn on when he flipped the switch, and got hit over the head. Once he was attacked, he hit the floor and lost his glasses. As he was getting up, he saw two blurs coming at him and he drew a pistol that he was carrying. Mr. Zeigler was not sure if the pistol fired, but eventually it jammed and he threw it. After that, he started flying around through the air and bouncing off the walls and refrigerators and the shelves that are in the back of that area. Eventually, he hit the desk inside the door where he kept a gun. Once he got the gun, he believes he fired it and then started swinging it with everything he had. Mr. Zeigler testified he was sure he connected with someone. After a further struggle, he was shot. Mr. Zeigler does not remember what occurred immediately after he was shot. The fact that the only blood on Mr. Zeigler's clothes came from Mays and from Mr. Zeigler himself is entirely consistent with Mr. Zeigler's trial testimony. And because Mr. Zeigler saw at least two perpetrators in the furniture store, it makes sense that someone else, an individual who was not caught or killed, and so whose clothing was not tested for DNA, fought with Perry and would have Perry's blood on his clothing. The state cannot explain why fighting with Mays would have left Mr. Zeigler with Mays' blood on him, while fighting with Perry would not have left Mr. Zeigler with Perry's blood on him. But under Mr. Zeigler's version of that night, the person that killed Perry likely did get blood on him. It was simply not Mr. Zeigler. Mr. Zeigler's testimony at trial is consistent with and supported by the newly discovered evidence. The totality of the evidence in Mr. Zeigler's case creates substantial reasonable doubt, and the court should grant Mr. Zeigler a new trial. 4. Additional evidence discovered since Mr. Zeigler's trial supports his innocence. The court must evaluate the newly discovered evidence in the context of all evidence admissible at a new trial, and the additional evidence Mr. Zeigler uncovered since his trial establishes reasonable doubt. At trial, the jury heard law enforcement testify about their investigation, culminating in charging Mr. Zeigler. What the jury did not hear is that law enforcement failed to investigate properly and instead coached witnesses to change their testimony to support the state's case. Further, a state eyewitness subsequently recanted a key part of his testimony, and he has maintained that recantation since. These create reasonable doubt and must be shown to a new jury. A. The investigators failed to investigate properly. At Mr. Zeigler's trial, the jury only saw a piece of the law enforcement failure in this case. With the added context of additional evidence discovered since trial, a new jury would see how the investigation failed to comply with accepted standards for homicide investigations. At the evidentiary hearing, Mr. Ibram Garcia, a veteran homicide detective with the Miami Beach Police Department, testified he oversaw homicide investigations for 13 years as a detective sergeant. He worked with and trained numerous local, state, county, and federal law enforcement agencies. Mr. Garcia reviewed interviews conducted by state attorney investigators and analyzed cold cases, some as old as 30 years prior, in his monthly training with the medical examiner's office. Mr. Garcia testified about the standard procedure of securing crime scenes by maintaining logs with details on all people entering and exiting. Mr. Garcia stated that securing the scene is necessary to best preserve the evidence. In 1976, Mr. Zeigler's trial jury heard Lieutenant Blankenship testify, "I know it's policy with the Sheriff's Department that anyone entering the crime scene would sign what we call a contamination sheet, Exhibit D. Yet, Lieutenant Blankenship did not recall signing such a sheet at the furniture store in this case. Mr. Garcia's review of the materials in this case revealed no such sheet." And further, the law enforcement chief in this case returned to the crime scene carrying previously removed evidence, Mr. Zeigler's clothing and shoes, further violating standard procedures at crime scenes. The jury heard that the state could not subtype blood found on car upholstery and on the telephone inside the Zeigler store. What the jury did not hear is that the law enforcement created the subtyping issue by failing to properly preserve the evidence. Further, investigators made up their minds early about where the evidence would lead their investigation, and then the investigators only found evidence to fit that theory. Investigators learned that Mr. Zeigler was shot in his lower right abdomen, with the bullet exiting the right side of his back. The gun used to shoot Mr. Zeigler, a .357 Magnum, is powerful and would cause severe damage, severe trauma. Mr. Zeigler is right-handed and he owned other smaller guns nearby at the crime scene. The jury did not hear how the trajectory of that bullet wound indicates it would be very unlikely for a right-handed person inflicting the wound on themselves. All the above failures by the state tend to create reasonable doubt. Any new jury must have the chance to evaluate the weight of the evidence. B. State investigators follow their own theory, not the evidence. Instead of following the evidence where it led them, law enforcement investigating the furniture store murders sought to fit evidence into their theory of what happened. Mr. Garcia testified that standard and proper law enforcement practices are to allow that person to give their statement, their account of what they actually witnessed, without telling the witnesses what the law enforcement wanted them to say. But in this case, State Attorney Investigator Jack Bachman did just that. As Mr. Garcia summarized, Investigator Bachman told a witness that because the witness's account did not comport with what Bachman expected, that testimony is no good to them. In Mr. Garcia's expert opinion, Bachman's comments regarding a free trip to Florida, if Mr. Jellison's witness account changed, were improper. It's inappropriate. It's incorrect. It should not have been said, even if it was a joke. The issue for the state was Mr. Jellison heard gunshots after he saw the officer, not the other way around, which contradicted the state's theory at trial. Mr. Jellison went outside his hotel room around 9 p.m. on Christmas Eve, and he saw a police officer leaning across the passenger side of his squad car hood, facing the furniture store's back. Mr. Jellison retreated to his motel room and continued to peek out intermittently through the curtains, and sometime after he first saw the officer, he heard multiple gunshots. Investigator Bachman told Mr. Jellison that he was almost on my way up to interview the Jellisons until he heard Mr. Jellison's account. Under Mr. Jellison's account, the police arrived at the scene and engaged in a shootout before Mr. Zeigler called for help around 9:15 p.m. In 1976, the jury did not hear from Mr. Jellison. The jury also did not hear that the state had attempted to coach and then dissuade a witness. This evidence undermines both the state's theory of the murders and its credibility. The jury did not hear from Mr. Jellison because the state withheld this exculpatory material in violation of Brady v. Maryland, 1963. By the time Mr. Zeigler's jury trial began on June 10, 1976, courts across Florida had cited to Brady 24 times. The state knew that Mr. Jellison was a material witness, and the state knowingly withheld his testimony from Mr. Zeigler. C. The state relied on a witness who recanted after trial. At trial, the jury heard Felton Thomas testified that Mr. Zeigler took him and another individual to an orange grove and encouraged them to shoot weapons Mr. Zeigler had brought. Thomas then testified that Mr. Zeigler took the two men back to the furniture store and attempted to break in before Mr. Zeigler decided to get keys from his home. Notably, Thomas's testimony helped the state build a case that Mr. Zeigler asked Thomas to shoot the weapon to get his fingerprints on them. Thomas's account of events was a key piece of the basis for the state's conviction in this case. See Zeigler v. State, Florida, 1981. But Thomas's print was not found on any of the guns. They were wiped clean. His prints were only found outside on a switch box. And since the trial in 1976, Thomas has recanted his testimony about shooting the guns. Mr. Thomas has now testified that only Mays fired a gun, and he adamantly denied ever taking one of the guns or shooting it from the window. If Mr. Zeigler did not try to get Thomas's prints on the gun, then Thomas's story of events does not make sense. Why else would Thomas be taken to the orange grove that day? And why did Thomas change his story? These are questions a new jury must be given the chance to consider. 5. None of the court's past holdings bar the relief sought here. A. Evidence from prior post-conviction proceedings are considered under the court's cumulative analysis. It is well established under Florida law that the court must consider admissible evidence presented in prior post-conviction proceeding as part of its cumulative analysis. As the Florida Supreme Court explained in Hilden in 2014, this court held in Lightbourne and more recently in Swafford, a post-conviction court must even consider testimony that was previously excluded as procedurally barred or presented in another post-conviction proceeding in determining if there is a probability of an acquittal. In Lightbourne, the Florida Supreme Court explained that even if the newly discovered evidence does not establish a Brady violation, it nonetheless may qualify as newly discovered evidence that a trial court should evaluate in light of the other evidence adduced since trial to determine whether it would probably produce a different result. And in Roberts v. State, Florida 2002, the Florida Supreme Court explained if the trial court determines on remand that the newly discovered evidence is credible, then the Brady claims raised and rejected in Roberts' first post-conviction motion must be considered in a cumulative analysis. Evidence that was previously raised and found procedurally barred is integral to the court's cumulative analysis here. In 1989, Mr. Zeigler's counsel filed a motion to vacate his convictions, one claim of which was premised on the Jellison tape. The court denied the claim as untimely because defendant did not demonstrate these issues could not have been discovered earlier. Likewise, in 2016, defendant moved for the issuance of a subpoena to compel Thomas to give testimony at a deposition and hearing concerning his recent recantation in an affidavit provided to the defense in 2015. The court denied the motion because it found that Rule 3.853 permitted only limited discovery for the purpose of obtaining DNA and did not permit lay witness testimony at a 3.835 evidentiary hearing. Despite being procedurally barred during his first post-conviction process, the Jellison tape from 1976, John Jellison's testimony, and Thomas's testimony would be admissible at a future trial and therefore are appropriately considered by the court today. See Hilden, a post-conviction court must even consider testimony that was previously excluded as procedurally barred. The Jones standard requires that in considering the effect of the newly discovered evidence, we consider all of the admissible evidence that could be introduced at a trial. B. The court's prior DNA-related decision does not bar Mr. Zeigler's relief. In 2003, Mr. Zeigler moved to vacate his conviction under the Florida Rules of Criminal Procedure 3.950, 3.851, and 3.853 based on the DNA results obtained from limited DNA testing conducted in 2001. The 2001 DNA testing had shown that the type A blood on Mr. Zeigler's shirt did not belong to Perry, and that Perry was likely the source of bloodstains on May's pants. The court denied Mr. Zeigler's motion. The court specifically highlighted that it was possible to miss blood on the shirt due to the deterioration in proper storage, and that it was also possible to have a mixed stain from multiple contributors in the same area. As a result, the court explained that the presence of May's blood and absence of Perry's on the defendant's t-shirt does not conclusively show that the defendant did not hold Perry in a headlock and beat him. This new DNA testing was designed to and did specifically address those concerns. Ms. Hardy Connell testified that she was able to generate reference profiles suitable for a comparison for each of the victims in the case despite the deterioration of the evidence. Ms. Hardy Connell was also able to obtain DNA profiles from mixed samples using the STR-Mix software. And finally, the state concedes that the evidence shows that Mr. Zeigler did not hold Perry in a headlock and beat him. I am also conceding that the evidence probably doesn't bear that out. 6. The court should set aside Mr. Zeigler's convictions and order Mr. Zeigler's immediate release from custody. Upon setting aside Mr. Zeigler's convictions, the court should order Mr. Zeigler's immediate release from custody. Mr. Zeigler is entitled to pretrial release. The burden of proof for pretrial detention lies with the state. Even under capital charges with a heightened standard of proof, the law still favors release. State v. Blair, Florida 2010. Unless charged with a capital offense or an offense punishable by life imprisonment and the proof of guilt is evident or the presumption is great, every person charged with a crime or violation of municipal or county ordinance shall be entitled to pretrial release on reasonable conditions. The state has discredited its own trial evidence, and thus the weight of any evidence against Mr. Zeigler is weak. Additionally, Mr. Zeigler poses no danger, much less an unreasonable danger, to the community. Mr. Zeigler is increasingly frail. Despite over 50 years on death row, he has remained a beloved member of his community. He requires a wheelchair and occasional oxygen. No pretrial conditions are necessary. Mr. Zeigler's convictions cannot stand in light of the cumulative new evidence adduced since his flawed trial. The convictions must be set aside and Mr. Zeigler set free. Respectfully submitted, Ralph Hadley. And, of course, the rest of the team. Excellent, excellent closing argument from the defense team. So there you go. That is the defense's closing argument from the evidentiary hearing held on December 1st through 5th, 2025. Again, another long read, and did my best, so sorry if I stumbled a bit, guys. But I am praying for Tommy and justice for Tommy, that the Judge Marquise, finds this reasonable doubt, because there's just so much of it. DNA, the stories changing, the witness statement from Jellison, just so many things. I mean, the DNA obviously is the icing, on the cake. It's the actual physical evidence besides testimonies. But I really am hoping and praying that her decision comes out very soon, and that Tommy immediately gets released from prison up in Jacksonville. And will they do another trial? I don't know. I mean, at his age, again, we've been saying it, he's very frail. And of course, Mr. Hadley ended it explaining that. Tommy is no danger to the community and society. So releasing him, pending the state deciding what they're going to do, I think there's no danger. And I don't think that they would prosecute him again. I mean, I could be wrong, but I don't think they will. And Tommy's ultimate goal has always been to clear his name. And I pray that Judge Marquise sees that his name has been blacklisted. I mean, his name has been, just dirtied. I mean, he didn't do this. And at the least, he should be released pending what the state decides to do. And that way the community and his name can at least come up with saying, you know what? There's just not enough evidence to show that Tommy did this. But let me know you guys' thoughts in the comments. I know a few of you guys have been commenting on these videos, and I do appreciate it. Whether or not you agree with me, that's totally okay. And of course, once we hear from the judge, you guys will know from me. I will definitely post it in the community tab before doing a video. And with that said, I hope you have a great rest of the day. And most of all, stay safe.